to work with Emily, and it's going to be, she's stuck with me for at least a semester until she quits then, or maybe she quits before. Hopefully she won't. But it makes it easier for me and for Emily at the end of the semester when we're figuring out whether you did everything you were supposed to do. Yeah.
So if we didn't email the cover page, she wants to email it now.
It's fine. It's fine. It's fine. Well, just today is like everybody gets a mulligan and blank slate. Let's see. Okay, that's it for the assignments, housekeeping stuff, separate emails, title page, blah, blah, blah. Well, that's it. Okay. Practice tip of the day, short and sweet. When you do a draft brief, put a table of contents on it. And why is that? It's because whoever's reviewing that draft, it makes it easier for them to see where you're going when you have that table of contents on there. I just reviewed something that was like long and didn't have a table of contents. I thought, oh, this would be so much easier if it did. Okay, let's talk about the title page. Okay, so here was the template. Okay, so we'll go around this one. I also need to make new flashcards for this semester. So today, let's try one word. Okay, so Zach, what is the first thing you should change on this template?
The case number?
The case number, okay. And go ahead and tell us, well here we'll just highlight what it should be. And what is the case number?
Was it 04A041502CR 00032?
It's 0033. No, I'm just kidding. But yeah, that sounds right to me. Okay, so then, Dimitri, what's the next thing that you should change on this template?
So the court?
Yep, and what court is it in?
So I think I got it wrong. I put Indiana Appellate Court, but in the Court of Appeals of Indiana?
Yeah, I think Court of Appeals of Indiana is probably a little better, but had you put Appellate Court, they would have at least known what you were talking about. Okay. Much better than putting, like, Traffic Court. Okay, so Bryce, what is the next thing to change?
The names of the parties.
Who is the plaintiff appellee in our case?
State of Indiana.
Yeah, and what if the plaintiff had lost at trial? Then what's the next thing you would need to change on this template? Our plaintiff won, so you didn't have to change this?
Appellant, really?
Yep.
Okay. Switching the titles, yeah.
So if the plaintiff had lost and was then appealing, then it would become plaintiff appellant. You'd have to change that. But, you didn't for this. And also, side note, if the government loses a criminal trial, they don't get to appeal. So, okay, and then double jeopardy clause. I don't know what that is. Maybe we shut the door. Let's do it. Okay, Sharia, what should we do next? Oh yeah, I forgot to put this in red. But then, what should we do next?
Change the on the appeal from.
Yeah, well, you should also change this party. And who is the defendant, appellant or appellate?
Ronald Miller.
Yep. Okay, and then go ahead and say on appeal from
the Circuit Court of Benton County.
Yep. So we change that, and then let's assume that you were the appellant here. The name would be changed here to what?
Ronald Miller.
Yep. And then this one was trickier. How did you, obviously this is not the right thing. Jacob, what would you change here?
I would assume to law school. Or...
So, so you're right that you would change it, but you could look in the record and find out the actual address of your firm. Or if you're the government, you could go online and look up whatever that county is, their prosecutor's office. And then you would also, let's say you were the appellant, you would need to change that there. So how would this all shake out? Let's say that you were representing Ronald Miller. Your cover page would look like this. That long case number that Zach gave us in the Court of Appeals of Indiana. State of Indiana is the plaintiff appellee. Ronald Miller is the defendant appellant on appeal from Circuit Court of Benton County. Brief of appellant Ronald Miller. Then here's the law firm that, according to the record, is representing him. And then don't forget to change that down there too. Then if you were the State of Indiana, just like we did, except we would say State of Indiana here, the Benton County Prosecutor's Office, Box 101. Could be, you could also, if it's the Commonwealth Attorney's Office, you could say Benton County Commonwealth, whatever it is online. Yeah, go ahead.
On the
District Attorney maybe.
on appeal from there in the middle,
Mm-hmm.
underneath it, why do we not put like for the, whatever district of Indiana or for the appeals of Indiana, like the other one had for the something district of
Let's see.
California.
Oh.
Oh, it's up from like the 13th district or something.
That one.
No, let's see where that
The middle
was.
something.
Where did it go? Okay, so it's on appeal from the United States District Court for the Middle District of California. That's because California has 3 or 4 district courts. They have a Northern District, Southern, Eastern, Middle, I don't know. But, whereas, so the most specific you could be on this brief was you could say it came from the United States District Court for the Middle District of California. The most specific you could be for our brief is to say it came from whatever that was. Circuit Court of Benton County. In other words, there's only one Circuit Court of Benton County. There may be different judges or different divisions.
There's only one you can put it, but you don't want to.
Say it again.
If there's only one, like, could we put for the Circuit Court of Benton County there, or should we not put anything at all?
You should put Circuit Court of Benton County.
Oh, I did do that, sorry. I was thinking underneath, never mind.
Okay.
Okay, so there's just nothing underneath this yellow.
Right.
Um,
Yeah. If you have a question, they probably have a question too.
On the instruction sheet,
Mhm.
and it said to put like your student number,
Yes.
so does that go like under student name?
It'll just, it says student name, but actually it should state student number. Although, actually, I'm glad it says student name because what you turned in today should have your name. But then when you turn it in at the end of the semester, it's anonymous, so replace your name with your student number.
Okay.
Yep.
So on the record, it's actually like an appeal, so there are 2 different case numbers.
So one of the case numbers is probably the trial case number.
Right.
And
so
one of them
that
is
wouldn't
the
be what-
appellate case number. You want the appellate case number
Okay.
for your appellate brief.
Okay.
Because I put the wrong one too. Can we go back over the font sizes? Because I copied and pasted it and they didn't like.
Yes. So one way to make sure when you're using a template that you don't alter the formatting is if you're going to, one way to do it is just to type it by hand and then it won't change the font size. So like let's say it was State of Kentucky. That won't change the font size. But let's say that I wanted to copy and paste something into this template. The best way to ensure that you don't change the formatting when you do that, instead of pasting, go to Edit, Paste, and Match Formatting. And that will keep it. Or sometimes that will not be allowed, but Paste Special will be allowed, and then you just click Unformatted Text, and that has the same effect.
It's deep. All right.
Deep. Yeah, that's it.
Would you ever put your work email at the bottom under the firm address? And
Yeah, I can see you doing that. That's probably evolved over time. They probably used to put their fax. So, other questions? Okay. Yeah, why don't you pass those up? Just pass it to the 2 sides and then.
What's that?
So, and here, while we're passing it up, talk with the person next to you about
Fisher.
the Jeff Fisher reading and things that you like or things that you do not like, writing principles that are exemplified by it, or that are, or flout it.
Sorry.
To read your last.
He had a lot of quotes.
Yeah,
It's like his court.
and
It was funny.
If it's paragraph,
yeah, he's
Said, is like.
The bottom.
different one. That's a different case.
So, Lee and Priya, what did you guys like? Or dislike?
I thought it was like at the beginning where he said it was like 1 through 4. He like stated his issue about the Commonwealth. I need to read this really quick. It was well, basically like he gave the issue and then he gave like historical context and did like the precedents in order and then he went back to it.
Okay, and so why was that effective?
Because I think it gave the reader a good like background context before addressing the issue.
Good. So it was well organized, and one of the ways that made it well organized was it had a kind of chronological aspect to it, which is easier for the reader to follow. And then I also think he to a degree he does broad to narrow, general to specific, which we talk about a lot. General is like how did we get here? What was the inspiration for all of this? And then how did we get here? And how did we get here? And how did we get specific here? So good. Zach, you were talking about quoting, and Sharia was too, and Bryce. So any of you tell us what you thought about that.
Just how he used like the court's previous decisions to like kind of throw it back in their face. Like, you've already said this, so
Good.
like,
Give
how
us
can you
examples.
disagree
Tell me
with?
page, chapter, and verse here.
22, the one
It was later on.
he said the second page. I think Bryce said.
Yeah.
So
Final?
23
Page 23.
on the top, 2 on the bottom.
Yeah, the top paragraph's like a full paragraph of quotes, but it doesn't feel like it when you're reading it.
Good. So one of the things Gardner suggests is use quotes, but weave them into your narrative. Don't do block quotes. And why is it good to use quotes? We were talking about this a little bit.
Oh, just because it's literally what the court has said before.
Yeah, you don't have to. The court doesn't have to take your word for it that you're right. The court can just read what the court has already said, and all right, that's precedent. So go from there. So good. I'll give some of the things I like. I like this brief a lot. It starts with the first paragraph. It's something of an elevator pitch. We talked with your deep issue statements last semester about, total stranger. You try to explain to them, even if they don't have a background in the law, what your case is about and why you should win, or why you're right if you're writing a memo. And you begin to persuade. And I think he kind of does that with the first paragraph there. And then second paragraph there is a roadmap. So we talked about umbrella paragraphs, roadmaps, previewing, that kind of thing. So I think you can kind of see that. I also think in terms of CREAC, this whole excerpt, almost the whole excerpt is the rule explanation part of CREAC. But he is following CREAC. This is an excerpt, but he does the rule explanation. And you can see at the end of this excerpt, he begins to do application. Once he's explained what the rule should be, he begins to apply it to the facts of our case. Organization, we were talking about that with Lee and Priya, but it's chronological. He starts with pretty old stuff, Blackstone, Walter Raleigh, the Romans,
The Bible,
the
yeah.
Bible. But then he moves forward from there. He has a theme, and one of his themes is emphasizing the importance of the Confrontation Clause, just how essential, how indispensable it is to justice. He's got this quote, which I think he uses more than once: "Greatest legal engine ever invented for the discovery of truth." Cross-examines the greatest legal engine ever invented for the discovery of truth. So he's saying to the court, like, this is not just some, wimpy right, like the Third Amendment, quartering troops in the house or something. Like, this is life and death. I think he makes it a pretty easy story to read. It's all relative. It would be an easier story to read if it were an easier point he was making. But it's a pretty complex topic, and I think he makes it about as digestible as he can. If you look at page 27 of the brief, which is page 6 of the supplement, that paragraph in the middle of the page, we talked a pretty fair amount last semester about, okay, if you're going to spend a paragraph talking about one case, what should your topic sentence be? And what should it not be? What should your topic sentence not be? Volunteers? Priya, I think you're next. If you're taking a paragraph, you're going to spend a paragraph and talk about a case. Maybe it's United States v. Johnson from your Brady memo. Maybe it's Hammond from this brief. Maybe it's Davis, whatever. You say, okay, the reader really needs to know a paragraph's worth of stuff about this case. I'm going to tell them about it. Your first sentence should not do what? What should it not talk about? What should not exclusively talk about? Kelsey is willing to be your phone friend.
Facts.
Facts, right? You don't want your topic sentence about United States v. Johnson to just be a description of the facts of Johnson. Why is that? Because you want your topic sentence to tell the reader why that case matters to our case. What is the legal principle that case stands for that matters for our case? Because legal principles transfer across cases. The facts of one case only matter to that one case. So what does he say when he begins this topic sentence about Hammond? By the way, he begins with the word "and," showing that you can begin a sentence with the word "and." You should not follow the grade school, elementary school teacher's rule that you can't begin sentences with "and" or "but." And this court's decision in Davis's companion case, Hammond v. Indiana, demonstrates broad core agreement over when that test is satisfied. And then he gets into the specifics of Hammond. In Hammond, an 8-justice majority held blah, 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 blah. And even there, the holding is general, and then from there he gets specific with the reason. As you are doing your brief later in the semester, you think, okay, I want to spend a paragraph talking about a case. Come back to Jeff Fisher. Come back to page 27 of Jeff Fisher's brief. Take a look at how he describes Hammond, and then do the same thing for whatever precedent you're writing about. Okay, other things people liked or disliked? Volunteers? Yeah, Elizabeth.
It's just like personal preference. I hate the format of this where the margins are huge and it's like one big column in the middle and everything seems scrunched together. It's like a sentence looks like a little mini paragraph because it's so scrunched.
I can kind of see that. Painful to read. Yeah, I mean, there's a reason people double space stuff. You will not get a choice when you're writing to a court. They have their own rules, and he's writing to Supreme Court. They have their own rules, so he didn't get a choice on that. But fair enough. Let's see, other things I liked or disliked. I think he does a nice job where he goes on the offense, he states what the rule should be, and then if you go to page 28, and then he shifts to saying why the rule shouldn't be what the state proposes. But even then he's staying on offense and he gives a roadmap. If you look at this, he says the primary purpose test, the bottom of page 28. The primary purpose test applies to statements elicited by teachers and other non-law enforcement personnel. This conclusion flows from history, precedent, and common sense. I'm going to guess that he will then discuss history, precedent, and common sense. So there's kind of like a subtle roadmap there. But the main point I'm making here is he goes on the offense, he tells the reader, here's my vision of the law, here's why you should agree with it. And after he's established that, then he turns to his opponent's argument, gives it short shrift, and then spends most of the time telling the reader why his opponent's argument is wrong. Criticisms, other than the formatting? I usually have criticisms, but I have to say, I don't really have any for this one. I like it a lot. All right, let's listen to an oral argument from this case. Same thing as last class. Think to yourself, take a note or two. What does he do well? If there's things that you don't think he does well, what does he not do well? What can we learn from his mistakes? What kinds of questions what categories of questions are the justices asking him? Are they asking, did we talk about different categories of questions last class? Okay, so keep an eye out for different categories of questions. I talked to the second class about these. One kind of question is is an extremely sympathetic question. So imagine that you are arguing for marriage equality before the Supreme Court. And imagine that you get a question from a justice who you know is going to be for marriage equality. And you get a question from Justice Ginsburg, for example. Justice Ginsburg may well use that opportunity to make an argument in your favor. she may not really be looking for information from you. She may just want to get out there for everyone to see a really good argument for your side. And so, you know, the thing to do when you get that kind of question is agree with it. You know, this is not like rocket science. But don't assume that every question you get is a hostile question. Then take one step back from that. A question from a justice or a judge who is either on the fence or leaning toward your side. But it's not a just total gimme question. It's not like they're saying, hey, isn't this a great argument? And all you have to do is say, yes, I agree, that's a great argument on my side. It's a help me help you question. It's like, okay, I want to get where you're going, but I'm having a little bit of trouble. So help me help you. Show me how I can get where you want me to get. But I'm facing this obstacle, so help me get past it. So you can look for help me help you questions. Then you can also look for, this is just a totally neutral question, could come from any justice or any judge. Help me with the facts. Help me with the record. Because even though appeals are not about what happened in terms of the facts below, they are about how to apply law to facts. And so knowledge of the record is essential in order to help the court apply law to facts. So they may just have a question about the record. Then kind of moving on the spectrum of hostility, you could get a slippery slope question. So justice says, no, if you're right about X, doesn't that mean that Y must also be true? And Y will be something horrendous, something terrible that no one would want to exist in the world. So then you have to, you know, figure out how you can distinguish X from Y there. So watch out for slippery slope questions. And then kind of at the extreme end of hostility, look for questions that fish for a concession. So you've got a judge who just doesn't like your argument and is going to say, wouldn't you have to admit, if you're true, that this is true? It's similar to the slippery slope question, but the hard thing about fishing for concession questions is if you refuse to concede, then it may look like you have a logical inconsistency with your argument. But if you do concede, then you may have just conceded your case away. So look for all those types of questions, and we'll, you know, it's kind of hard to explain them in the abstract or process it in the abstract, but you'll see it throughout the semester, different ones. Okay.
Social services and the police, Ohio law quite explicitly and unambiguously requires the social services agency to share information of any possible abuse, criminal abuse with the police, and also the Cuyahoga County's own guidelines, which we cite in our brief. So there's no doubt those two things are intertwined. And secondly, the mandatory reporter statute, along with Ohio Rule 807, expressly make these statements admissible in criminal court proceedings. So you put all this together, and I just think it's frankly undeniable that the criminal process is hanging over this. And so really the only hard problem, as I think the one Justice Ginsburg is asking, is how do you disentangle that, or how do you weigh that against the protective purpose, which the teacher must have had as well?
Mr. Fisher, can I ask a question that steps back a little bit? Because it seems to me that the strongest part of your case goes something like this. This is a statement that's going to come in and is going to have great consequence in a trial. It's going to function as the most relevant kind of testimony imaginable. It's an accusation. In a case like this, there are two potential parties that could be accused. Essentially, this is fingering one of them. And it's being done by a 3-year-old. And the question of whether that's a particularly reliable way to choose between which of these two potential people did it is like a little bit scary. And then you're not being able to question it, you're not being able to do the things that you normally do. Okay, so all of that seems to me, that's your strongest case. And it seems to me that it doesn't fit very well with the test we have and with the questions that we're supposed to ask. In other words, all of what I said seems to be, or most of what I said at least, seems to me kind of irrelevant to the question that we ask under the primary purpose test. And what do we do with that lack of fit?
I think I can answer that question while also going back to the question I posed before you asked the question, which is what do you do when it's too difficult to pinpoint a purpose? The court has also described in its cases the very helpful inquiry of whether the statement when it's introduced in court functions as an in-court substitute for trial testimony. That is exactly what the testimonial test is designed to answer. And I think part of the
See, I
power
don't
of
think it
the...
really does. I mean,
Yeah.
the way I've always understood the primary purpose test is that it's not whether it functions at trial as testimony or how the jury understands it. It really is how the declarant understands it, maybe leavened by some, what does the questioner think and what are the circumstances. But it seems to be mostly about the purpose of the person who's making the statement, which fits, not very well with these kinds of concerns that you're talking about.
Well, I think the linkage between the two is that when a statement is made outside the courtroom for the primary purpose of establishing facts that might be relevant to a later criminal prosecution, then when it's transported into the courtroom, it does perform the substitute of trial testimony, which is exactly why you so accurately said so there was such power in this statement. The prosecutor at closing said just as she would have said if LP had taken the stand. She said, when this child of 3.5 years old is asked who did it, she said D did it. He said D did it. And so the way the prosecutor presented it to the jury was as a precise, perfect substitute for in-court testimony. And it's not, I think, disjointed from the fact that outside the courtroom, the statement was made to establish a fact relevant to prosecution. It's difficult.
All admissible hearsay is a substitute for in-court testimony. So the test you just gave us seems to me to encompass all hearsay, doesn't it?
No, I think a jury would view a stray remark to an acquaintance, as the court has put it, as a piece of evidence, relevant evidence perhaps, but not as testimony. It wouldn't make sense to describe somebody's, I think this court has put it this way, somebody's stray remark to an acquaintance or somebody's cry for help later on as somebody's testimony. But here, this is exactly LP's testimony. That's what it is functioning as. And if I could turn to one other piece of Ohio law that I think is important to have before you. We've talked about Ohio rules of evidence.
All right, so talk with the person next to you for about a minute or two, and things that he did well, things he did poorly. What types of questions were Justice Kagan and Justice Alito asking him, and go from there.
I think Alito's, I felt like Kagan's was question type too.
Yeah.
But then some people are probably going to say that this. At first, I thought it was a solution thing, but
Yeah,
there
first
was
I thought she was kind of going against them.
Yeah. So I don't know. She kind of just said take your pick on it.
Yeah.
And then the other question I didn't really get to hear.
Yeah, I don't even know what you're
Mark it down.
Is there any way? Was it asking to scroll up to the other question?
What do you guys think? What do you think the read is?
What y'all think about the Kagan question? Was it one or two? That's the question right now.
He doesn't know anything.
I know. I'm trying to read it. No, I read it. This. Yeah.
Oh, I was going to say, dang, Demetri.
I thought he didn't really. But I don't know. So what kind of question do you think Elena Kagan was? Was it a fact one or was it a...
Was it help me help you?
Yeah, I heard
Yeah.
that say that.
I think
Okay.
she's trying to get on his side.
Okay.
She's usually like the swing.
Okay.
Help me help you.
There you go.
I'm serious.
Okay.
That's how you keep class. I don't know what I'm supposed to be asking.
It's always good.
Yeah.
At least you showed up.
I have to.
Well, not
It's
everybody.
like-
Not everybody did. But
I guess actually maybe
So Shara, what do you
we're always saying, I know the testing only was
Slackers. A lot of you.
but even
I don't have anything insightful. That's surprising.
Shar is a deep thinker.
Shara's always
You
got
can
something
tell.
insightful to say too.
but I don't think that he did a great job. I think Justice Kagan was saying.
That's what he told you guys about your
I don't even know about it. I know we show up and it's mandatory on a Saturday.
That's good to know.
At least you know that. At least you know when to be there.
Turns out they don't.
Probably guarantee yourself.
I'm excited about it.
But I know that all of them.
They'll make it fun. Yeah.
It's
That's my
fun.
jam.
Is it?
It's not for a grade.
Oh.
No.
It's not.
No.
So we don't have to show up.
No, you
Oh,
have
you have to sign in. But he lets you practice in here.
Oh, okay.
It's
I feel like we'll know the case so well.
Yeah, hopefully.
That's the 4 months.
That's the goal.
20
And the
hours.
questions they ask you are
Alright,
like
we'll
the
talk about
ones
all
he's
that.
already asked you.
Oh, that's great.
Okay,
Like,
great. Great. Volunteers? Yeah, great. You were going to be the required person next, so might as well volunteer.
Like right before where it's highlighted right now, where Alito like talks about like municipal hearsay, it's kind of like he's like fishing, like trying to get Fisher to admit that the child statements like aren't really the thing. Just trying to like fish and like get him to say something that he doesn't want to say.
I think that's exactly right. Let's put this in so Justice Alito, what kind of question was he asking if we use the categories that I was talking about earlier? You kind of said it already, but fishing for a concession, I think. What is the concession he's fishing for? I think one of them is like, okay, if you're right, like, doesn't this blow up hearsay law? And courts are hesitant to take drastic, nuclear measures like that. And it's not surprising that his question is a hostile question. You'll see this as you research the Confrontation Clause more. Justice Alito hates the Confrontation Clause, basically, and he pretty much hates all criminal procedure protections for criminal defendants. But Confrontation Clause is probably at the top of his list. And so he gets a hostile question. But Justice Kagan's question, I don't think is coming from a position of hostility. It's not an easy question she's asking, but we were talking earlier. What kind of question is it? What do you think?
We thought, help me, help you.
Yeah, I think it
Help
is.
us.
I think it is. It's not help me, help you. I'm already on your side, but I'm on the fence. My instinct tells me there's something to your position, right? I am terrified at the thought of a 3-year-old being able to make an out-of-court statement that is not cross-examined, and that statement alone sends someone to prison for 20 years or whatever. I have a 4-year-old. She lies all the time. And it's not because she doesn't do it maliciously, but she's still learning to distinguish between. And honestly, she's a lot better at 4.5 than she was at 3.5. We talk about how it's not right to lie, but that's a conversation we've had in the last 6 months. It's not a conversation we had when she was like 3. So I think Justice Kagan feels like there's something to your position here, but I'm not ready to rule for you because under the test that the court has used for the past 10 or 20 years, you lose. So give me a different test. Help me create a different test that you will be able to win under. And so I think it is a help me help you question. How do you think he did in answering her question? Yeah.
I thought he was more fluid than like the last brief. He's kind of methodical. When Kagan asked that question, he absorbed hers and then went on to kind of reflect it.
I think that's right. Yeah, I think he's very good. Not perfect. I think one of the things that's best about him is his tone. He has a conversational tone. It's not a overly informal tone, but it's also not a combative tone. And so that's something I think you should strive for, regardless of what court you're arguing in front of. Again, Supreme Court with 9 justices, State Supreme Court, Circuit Court on a death penalty case where you're arguing a motion to exclude crucial evidence, Circuit Court case for, drunk driving, a Circuit Court case where there's a traffic accident, whatever the case is, doesn't matter what the stakes are, it doesn't matter what the court is. Ideally, most of, if not all of, the lawyering skills we talk about in this class transfer from civil to criminal, from trial to appellate. And so, you're in court, there's one judge, the judge is asking you questions. It's good to not be overly informal, but it's also good to not be so formal that you're combative, or robotic. And I think he does a nice job of being conversational. She asks a help me help you question, and he responds the way like a thoughtful person would, who's trying to help the questioner. So I think his tone is good. I also think his knowledge of the precedents and the record doesn't come across as much with this excerpt, but he knows the precedents backwards and forwards. He knows the record. He knows the state law. You hear him kind of alluding to this. And he's doing it all without notes, or with at most one-page notes. So I think it's a pretty impressive performance. Other thoughts? Any more argument? Yeah.
Well, I liked how she said that's a powerful statement, and she went on to say a bunch of other things, and then later he said, like you said, it's a powerful statement. So I thought that was clearly showing that he's listening and reiterating what she's already thinking.
I think that's exactly right. And what Emily said, there's several lessons there to keep in mind when you're litigating. One is to listen. It's hard because you're up there and you're thinking about what you're going to say next, and that in itself is a challenge. But don't forget to listen. It's really important. What you will not, no matter how hard you think about what you're going to say, you will not say the right thing if you haven't listened to what the question is, and if you don't remember what they've asked in the past. You weren't listening then. Then also use their words, not against them, but use their words to help your argument. Almost every judge will prefer to trust something they've said in the past to something that you are just saying, and ask them to take your word for it. And that's true not just for an oral argument motion or an oral argument like this, but it's true when you're writing. We were talking about this earlier, but a good brief will use quotes from that court, and ideally from the judges on that court who are still on that court, and will use those quotes as part of their ammunition. Because judges like to agree with themselves. And also, it's not just that, but if they thought it yesterday, they probably still think it today. So you don't have to wonder whether they're going to agree with that piece of ammunition or not. Okay, good. Let's see if I had any other notes about it. Okay, that's all for that. Anything you did wrong? I thought that, for one thing, this is small, but he calls the kid a she instead of a he, so that's probably just nerves or something like that. And then, Justice Kagan asked this really hard question, which is, I kind of want to rule for you, but you don't win under a current test. Give me a different test. And I think he ultimately does not create a different test that makes a whole lot of sense. So it may be that it's not his fault. There's just not one out there. But I think he did a lot of things right. But in terms of the substance of answering that question, I'm not sure it was great. All right. Who had the Jeff Fisher reading? Who's the lead? Okay. Tell us the rest of the story. Do you know who won the case?
No, I didn't prepare for it that way. I just wrote down the stuff I liked about it.
Okay, so in future, two things. You want to do that. That's the first thing. You want to say why you liked it, but then also come prepared to tell the rest of the story. Who won the case, and if there's anything interesting beyond that. So I'll do the rest of the story for this one. Although I think his brief was very good and his oral argument was very good, he gets crushed and loses. I mean, I think the court is just not excited about making a 3-year-old come to trial and testify at the witness stand and be cross-examined and have to face his alleged abuser. And in part because, obviously the 3-year-old did not make the statement to the teacher thinking this will be used in a criminal trial against D. Right? So I'm not sure he really had a chance there. But you'll see in your research, if you look at this case, that the majority opinion is kind of oh, ho, hum, pretty kind of makes sense. But Justice Scalia writes a concurrence saying okay, I join the majority opinion, but just so you all know, this majority opinion hates the Confrontation Clause. That's outrageous. I love the Confrontation Clause, and the court is drifting away from it. And so keep that in mind when you're writing your brief. Okay. What else? so let's do our first vote of the year. We will do, where are we here? Right here, Estrada versus Fisher. So who had, oh, and we need to assign Jacob and Bailey briefs. So here, I'm just gonna run through these. If you have them, just say, I've got it. All right, Landau, Roberts.
Which Roberts is that? Is that the first
Alaska.
Roberts?
Actually, I think I remember a lot of these. Landau, Roberts, Hungar, Ginsburg, Scalia, DOJ. Did anyone pick Estrada?
Estrada and Roberts are the two that are missing.
Okay, and which Roberts? The Alaska or the?
I got the last Roberts, though. Ohio.
Okay.
Is that the last
Yeah,
one?
Pennsylvania be done left. Okay,
Yeah.
good. So why don't the two of you do Roberts as Alaska together when we get there, and I'll do Estrada because you didn't prepare for that one too. Okay, so the Estrada brief, things that it did well, it had that chart. Remember that chart? I thought it was like pretty effective in showing how crazy it was that the prosecution withheld the pretrial statements by Stolfus. It had a pretty good theme. The prosecution's whole case was Stolfus, and Stolfus lied, so therefore the conviction should be vacated. And then if I were going to do like negative campaigning against Fisher, I would normally do that here, but as I already told you, I really like the Fisher brief. So. Okay, tell us about the Fisher brief. Why should we go for it?
Like we've already said, like how it does the chronological order at the beginning, kind of gives like a lot of past in the 1700s, the Roman times, biblical times. Kind of just relates to a lot of things that people already know. And then he kind of breaks down the law and explains it through the rule of explanation part of the CREA Act. And then just the part I liked the best was at the end, or not in the end, towards the middle when he said like this court's previous rulings. He kind of tried to counteract what they've already said. I think that was a real smart strategy in how he wrote it, just to kind of sway the readers as well as the justices. And then lastly, just also at the end when he's talking about other cases where 2.5-year-olds and 4-year-olds have given testimonies in court, it kind of contradicts where they said that the child was incompetent to be in court. So I think those reasons alone, it's just really easy to read and would easily sway someone that didn't know much about the law.
Good, good. I like that. I agree with all of that. So let's vote. Who votes for Estrada? I like, oh, wow, look at this. Okay, good. So 4 votes for Estrada, and who votes for Fisher? Well, Fisher wins, but I have to say that considering how bad a job I did of advocating for Estrada, I like that he still got 4 votes. Good for you all. Okay, so let's see. Next class we'll read. We'll have another vote because we're doing 2 readings. We're reading Greg Garr's brief and again Jeff Fisher's brief in Melendez-Diaz, which is the cocaine test one. So speaking of, I'll prep that just a little bit.
So that's the same case, right?
Yeah, the 2 excerpts that you'll read for next class are both, they're on opposite sides of the same case. And I really already talked about this, so I'm not going to spend much time. But the guy gets arrested for possessing cocaine, and the government does a cocaine test, and then they want to admit that cocaine test into evidence. And the defense says, if you want to admit it into evidence, you have to call the lab technician who ran the test. And otherwise, we can't cross-examine the person who did it, and that violates our right to confront this witness against us. So extremely relevant to your all's appellate brief. Let's see. Okay, and the last thing, we're going to end early today. Anyway, is just some tips. So I used to assign this article. I just like be totally candid. I loved this article. It was maybe my second favorite article I signed on, and it was about how to lose an appellate case. And so you know, it's written tongue-in-cheek. Like, it's really giving advice for how to win an appellate case, but it's saying, like, if you really want to lose an appellate case, here's all the things that you should do. It's a little bit similar to, he doesn't teach 1L classes, but at some point some of you will have Professor Weaver. And one time the dean, not this dean, not even the previous dean, made him write a blog. And Professor Weaver does not like being told what to do at all. So he created a blog about bad deans, how to be a bad dean. Awesome. Rule number 1 was like, make it all about yourself. Believe that your job is really just an ego glory project, and that the faculty knows nothing. Their experience counts for nothing, and you know everything. Anyway, it's great. It was great. So anyway, this article is written in a similar vein, and it has lots of great advice about how to actually win. But it was written by a judge, Kaczynski, who turned out to be like a sexual predator and a monster. And so I don't assign anymore, and I hate him. But he did give really good advice in this thing. So I'm just going to paraphrase it, and that will be my advice, and not Judge Kaczynski's advice. He says, on the writing front, you should ask for more pages if you want to lose a case. You know, tell the judge right away that your case is so weak that you can't make it effectively within the page limits that everyone else plays by. You want to bind the brief poorly, maybe make every other page upside down. By the way, like when you all turn, some people turn in memos that are that are double-sided, which is not like a huge deal. It does make it like slightly more difficult. So, you know, make sure your toner is low on your printer. That's a good way to increase your chances of losing the case. Cheat on the page limit. So like, you fit the page limit, but instead of doing 12-point font, you do 11.5 font. But you're writing to a judge who, like, all their job is to read briefs all day, every day. So they know what 12-point font looks like. They have 1,000 other briefs to compare your brief to. They can see if it's 11.5. Bury your best argument behind 10 others. Use lots of acronyms that are obscure. Make ad hominem attacks on opposing counsel, and make ad hominem attacks on the trial judge. It's a really good way to lose a case because the trial judges often work in the same building as the appellate judges. You know, they probably had like lunch that day or played golf the weekend before, and so it's great to make an ad hominem attack on the appellate judge's buddy because that will increase your chances of losing the case. Ignore the statutory language, ignore the text, don't quote it. Use lots of block quotes because anyway, we talked about block quotes last class. Yeah. And then an oral argument, he says, here are some good ways to lose your case. Don't know the record at all. Just assume that the appeal is all about law, not facts. And so, you know, be utterly unable to answer any judge's question about how the law fits your facts. Overstate the strength of your case. Resist being interrupted. So like if the judge interrupts you, like resist that because yes, the judge probably has like a question that's important to that judge, but who cares what's important to the judge? What really matters is you get to say what you want to say. Stonewall, interrupt the judge. Don't bring the excerpts of the record to the case. So like, you know, to the argument, so that, you know, if there is a question, you haven't memorized every word of the record, you just won't be able to answer the question, and that'll be a great way to help lose your case. And then the last suggestion is make a jury argument. Appeal to emotion and totally ignore the law and just, you know, pretend like you're arguing to someone who never went to law school. Sorry you can't read the article. Sorry that he's a horrible person. He gives great advice about appellate arguing and really trial court arguing as well. So follow that advice. Anything else? All right, so we're done a half hour early, so that means we'll go a half hour later now.